online to hear me. So that means you just have to try to hear me. I hope that I'm loud enough. Welcome to the annual Ainsworth Lecture that we are so honored to hold here at Loyola every year. It is really our pleasure to create a lecture that exemplifies sort of what we look for in America, which is an opportunity for discourse across all sorts of perspectives and thinking. And it's so fitting that it should honor Judge Robert Ainsworth, who was our most distinguished alum, who served on the Eastern District here, and then on the United States Fifth Circuit Court of Appeal, which many of you all know and have maybe worked in or at least gone to visit. It's one of the great things about being here at Loyola as a student. Professor Snowden will take the opportunity to introduce our speaker. I just want to say just a word about Judge Ainsworth. Prior Ainsworth lecturers have been, our inaugural Ainsworth lecturer was Chief Justice Burger of the United States Supreme Court. Justice Ginsburg has also been an Ainsworth lecturer, and most recently, and there's a long list that you can go see online, but most recently, Justice Amy Coney Barrett was our Ainsworth lecturer. And so it's been our great honor to have a long line of people, part of being part of the cool thing, and that's a very legal word, of being part of an academy is the opportunity to engage in the work of academia and the work of Big Think and the work of thinking about what the world is doing and what it should be doing. So spaces like this are really, really important. Those of you that know me as a moot courter know that I never read my notes, and so I'm not reading these notes. But it is important for me to quote someone, if you're quoting somebody else, to read it accurately. And before I do that, I just want to welcome members of the Ainsworth family. If y'all can please stand and let us acknowledge you, John and Jenny. His mom is 93. 4 maybe. She and my mom, 91. She and my mom are dear friends. They each had 9 children. And Mom said, I didn't think she had 9. I said, you thought she had more? Like, what are y'all doing? What are y'all, like, in a race to see who can have the most children? Anyway, it's just such an honor, and please give her our best. In 2002, when Justice Ruth Bader Ginsburg was our lecturer, she said this about Judge Ainsworth, that he merits a place in history, first as a state senator who resisted blatant segregationist bills, then as a wise and good judge whose moderate, consistent, and forward-looking views helped keep the Fifth Circuit steady during the tumultuous times of the 1960s. It's altogether fitting that his colleagues and family and friends have chosen to remember him by founding and maintaining the Ainsworth Memorial Lecture Series at his alma mater. It could not be said any better by anyone more significant in the world of legal scholarship. And so it is just great, and I want to say thank you to all of you, our faculty, our staff, our students, for being here with us, members of the bar. Thank you very much for coming, and a special shout out and thank you to the faculty committee that has brought our fabulous speaker here, and thank you, sir. We look forward to your lecture. I turn it over to Professor Snowden.
Professor Steve Vladeck is many things, and I'm here today just to mention a few. If I were to guess based on his Twitter account and his Sky Blue account, his second love after his wife and kids is probably the United States Supreme Court. And I don't necessarily think that his love for the court only comes from his 5 favorite Supreme Court adjacent movies, which include The Pelican Brief, Separate but Equal, Loving, Muhammad Ali's Greatest Fight, and Confirmation, which features New Orleans' own Wendell Pierce. It could also come from his opportunity to argue in front of the United States Supreme Court himself. But one thing that we know is when we love something and we see something that we love change into something that we no longer recognize, we speak out about it. And Professor Vladeck has done that most recently in his book entitled The Shadow Docket, which looks at the United States Supreme Court use of the stealth rulings to amass power and think about the ways in which it's undermining our republic. Professor Vladeck has also spoken out about it through his allegedly weekly newsletter. And I say allegedly because my email pings more than just once every 7 days with his insightful commentary about what the Supreme Court is doing. But he also has spoken out about it in public discussions and in public debates, which unfortunately at times have caused him to receive personal criticism instead of substantive disagreement. But when we think about the work that Professor Vladeck does, I want to highlight a quote that he shared last year. His work is rooted in observing the declining legitimacy of our Supreme Court, and what he said was, to pretend the court's legitimacy is not declining is to bury our heads in the sand. And when we lift our heads up and look around, we may not recognize the federal judiciary that is left, not because it is no longer independent, but because it is so independent, no one listens to it anymore. I end with this quote from a man who happens to share the same last name as me, but we are of no relation. He said, "There can be no faith in government if our highest offices are excused from scrutiny." Professor Vladeck's work is focused on the legitimacy of our Supreme Court, and tonight we are in for a treat to learn more about the Supreme Court we need and why the court is worth saving, especially from itself. So please join me in welcoming Professor Steve Vladeck.
That bottom right picture is a story unto itself, but maybe we'll say that for the Q&A. Will, thank you for that delightful introduction. Dean Landrieu, everyone, thank you so much for inviting me for this. To the Ainsworth family, I can't tell you how much of an honor it is for me to even be in the same sentence as Judge Ainsworth. So it's really a treat for me to be here. Will sort of gave Professor Snowden gave a bit of the spoiler alert of what I was going to talk about tonight, but my goal is to persuade you in our time this evening both what is really wrong with the Supreme Court today and why it's worth saving. And my hope is that by the end, this will have been a conversation that's largely not about the results of the individual cases, but more about the Supreme Court as an institution. I like to start with the Supreme Court we have before we get to the Supreme Court we need. Y'all recognize this picture? Okay, good, a lot of you recognize it. Do you know it's not real? So I love to start with this. This is the official picture. It's called, colloquially, the class photo of the Supreme Court of the United States, and it never actually happened. What the justices actually do is they do a composite, where they take a whole bunch of different pictures, and each justice gets to pick the one in which they look the best. Right? So this is a digital composite. Couldn't be less important, right? Like, I came to this public lecture, I learned that the actual official class photo of the Supreme Court is a digital composite. But it actually helps to make a point, which is that everything about the Supreme Court is carefully choreographed. It's manicured. It is, preserved sort of very, very deliberately for public exposure. And that actually often makes it hard to talk about the court as an institution, because the court is trying so hard to present an image to us that is not necessarily, for lack of a better word, accurate. While we're having this conversation, the public credibility of the Supreme Court is in fact sliding. Professor Snowden mentioned my quote. It's not just me, it's Gallup, right, which is, for as long as Gallup has surveyed public confidence in the Supreme Court, it is at an all-time low. We can debate why that's happened. We can debate who caused it. Seems hard to debate the numerical fact that the Supreme Court is less popular today than at any point since it has been measured. Why is that relevant? Because the less popular the court is, the less power it has. The court's power is historically soft power. It depends upon some degree of diffuse public support. And meanwhile, the court that is more controversial and less popular is, if you haven't noticed, actually doing less. This crazy chart that you see right now is the Supreme Court's workload over time. It's the total number of cases the court has decided through full opinions every year going back to the founding. And you might notice at the bottom right, things are on the decline. That's where we are today. Those are the total number of signed decisions in merits cases each of the last 6 terms. And the reason why I start with the last 6 terms is before 2019, the last time the court had decided fewer than 60 cases was 1864, which at least when I was at UT, we called the War of Northern Aggression. New Orleans, I know it's a little more complicated, right? Why is this happening? How can the court simultaneously be more of a lightning rod, be less popular, and is actually doing so much less, right? This is one of the interesting, problematic, confounding paradoxes of the Supreme Court today. A Supreme Court that's doing less and pissing us off more. Why? Well, so let's talk about what the court's doing right now. Supreme Court in 2025, the October 2025 term just started, 2 weeks ago, right? And already the court has on its docket a bunch of super high profile, ideologically charged, politically divisive cases. Cases in which everyone expects the court to split 6-3. And I think I don't have to tell you which 6 and which 3, I suspect. Even the 1Ls, right? I have 122 1Ls in CivPro right now. We have fun. All right. So the conversion therapy case from 2 weeks ago, where it certainly looks like the court is going to go 6-3 against, right? The Louisiana redistricting case, maybe a little closer to home. You guys probably have heard of this one, where the oral argument sure makes it sound like the court's going to take another bite out of the Voting Rights Act. Transgender discrimination, the court later this term is going to confront the question it dodged in Skirmetti about whether overt transgender-based discrimination violates the Constitution. Campaign contribution limits, everyone's favorite topic. Right? The court has yet another case about whether these kinds of limits are unconstitutional, a case that was actually filed by then Senator J.D. Vance, just in case it wasn't clear which way this one was going. But note how it's like a fait accompli, how the court's going to rule in these cases. And these are the exact kind of cases that Justice White used to say, right? These kinds of cases are those in which we are the most vulnerable. And we come the nearest to illegitimacy, because these are the kinds of cases in which the court is doing more than interpreting statutes, in which the court is not producing strange bedfellows, in which the court is expending the finite capital it has. And so we have this remarkable confluence of a court that's deciding less, but more of its docket is the kinds of cases that tend to produce this kind of backlash, right? More of these cases are dividing the court ideologically as opposed to the strange, weird, splits you see in technical disputes. Then we have what's happening on the emergency side of the docket, right? There's this great debate happening right now, especially in right-of-center commentariat land, about what to call the court's emergency applications, because shadow docket is too ominous. I thought shadows were the natural consequence of placing an object in front of a light source, but it's 2025, things don't mean what they used to mean. But whatever you call it, no one can deny that emergency applications, intervening at an early stage of the case, have become a much more important and, dare I say, much more controversial part of the Supreme Court's work. This is what the rulings tend to look like. And if you're wondering where the rest of the majority opinion is, you're not missing anything, right? This is in the Department of Education case, where a district judge in Boston had blocked the Trump administration's effort to dismantle the Department of Education, where the First Circuit had denied a stay while the administration was appealing, and where the Supreme Court granted a stay without telling us why. Why is that important? Well, first, it clears the way for the Trump administration to keep doing the thing that 2 different lower courts thought was unlawful. Second, if you actually go and read the emergency application in this case, the Trump administration offered 3 different arguments for why it was likely to prevail, for why the lower court ruling should be stayed. One was that the plaintiffs lacked standing. Con law students, sound familiar? Standing? Have we done standing yet? We've done it, yes. We're allergic to it, but we've done it. Heard of it. One was that they filed in the wrong court, and one was on the merits. Those are 3 very different reasons why the Supreme Court might have ruled for the Trump administration. We don't know why. We just know this is happening all the time. Since President Trump came to office in January, he has filed 29 emergency applications in the Supreme Court. Just to put that number into comparison, during the entirety of the Bush and Obama administrations, so 16 years, 2 very different 2-term presidencies, the federal government sought emergency relief 8 times. I know we went to law school, so we would not have to do math. But, right, we've gone from once every other year to, at various points this year, once a week. Even as I stand here, right, there are two really important emergency applications from the Trump administration in the Supreme Court. One about deploying federalized National Guard troops into Chicago. One about whether, from this day forth, anyone who gets a U.S. passport has to put their biological sex at birth on the passport as opposed to their gender identity. Slightly different cases, but they're a good manifestation of how we got here. The court is doing more and more of this. And whatever you think of the results in these cases, these are high-profile decisions producing major effects, usually dividing the court ideologically. Most of them have been 6-3, in which the typical historical thing the court would use to defend itself against charges of illegitimacy was writing an opinion to persuade us. And there's no opinion to read, right? So all of this happening at the same time. So what's wrong? So part of it is that the court's rulings are producing these massive effects, but usually without explanations, like in the Department of Education case. If we went really further into the weeds, the court's interventions are based on the idea that every time a lower court blocks a government policy, the government is irreparably harmed. You actually peel that away, it doesn't quite make sense. The theory traces to something called the presumption of constitutionality, the idea that statutes come to court with a presumption of legitimacy. In some of the Trump cases, the challenge, the argument is that Trump is violating statutes. So how could the presumption of constitutionality tilt in favor of relief for violating a statute? It would be great if the court would tell us. It hasn't, right? The court's refusing to balance the equities even when plaintiff's harms are greater. So in the ICE raids case, for example, Justice Kavanaugh wrote a concurring opinion where he says, obviously the government has a significant interest in deterring and stopping unlawful immigration in Southern California. He never even accounts for the 90% of the Latino population in Southern California who are either citizens, LPRs, or otherwise have lawful immigration status, but are nevertheless subject to these same arrests and these same stops. That seems like a pretty big harm to account for. Certainly the court is acting in ways that at least appear to be inconsistent with non-Trump emergency applications. Here I mean both applications in cases involving states. For example, there was a challenge to Mississippi's age verification law for social media, where the court says, oh, we think you're likely to win, but we're not granting relief because we're balancing the equities. Now we balance the equities. But then there's my favorite, treating unexplained orders as precedents and chastising lower courts for defying them. Right? So, hey, district judge, you should have understood that when we wrote this, we meant all kinds of things we didn't tell you. Right? There's a reason why over the last 2 months we have seen an unprecedented number of news stories in which federal judges, district judges, circuit judges are being quoted as criticizing the Supreme Court publicly. It's because in August, Justice Gorsuch wrote this concurring opinion chastising 3 lower court judges for not following these orders as precedents. Right? This is all provoking criticism of the court. But I want to suggest it is also, right, emblematic of a broader problem. And I think the problem is really perfectly encapsulated in this amazing quote from the guy who says the quiet part out loud, Justice Alito. So in 2023, in an interview with the Wall Street Journal, Justice Alito says, I know this is a controversial view, but I'm willing to say it. By the way, always a good way to start a quote, right? No provision in the Constitution gives Congress the authority to regulate the Supreme Court, period. The period, by the way, is what makes it art. Or if you prefer, Article 3 is what makes it art. Because here is Article 3, Section 2, Clause 2 of the Constitution, which, if you jump to the yellow highlight, literally gives Congress the power to regulate the Supreme Court's appellate jurisdiction. Right? So it's not, I mean, I'm not here to tell you, aha, Alito was wrong, right? Rather, the point is Alito's quote is reflecting what's in the water, that the court doesn't think Congress should be allowed to regulate it, right? That the court acts as if Congress doesn't regulate it. And this is the thesis, right? The thesis is that what really separates the current court from its predecessors is not that there are 6 conservatives and 3 more progressives. That's been true at various other points in American history. right? It's not any unique feature of this political moment. It's that we have a court that, for various reasons, is not and does not believe it ought to be accountable to the other branches of government to the same extent as its predecessors. The Alito quote's a good example of this. Another good example is in April 2023 when Chief Justice Roberts refuses an invitation from Senator Durbin, who at the time was chair of the Senate Judiciary Committee, to come testify before the committee. He says, testimony before the Senate Judiciary Committee by the Chief Justice is exceedingly rare, as one might expect in light of separation of powers concerns and the importance of preserving judicial independence. Well, turns out testimony before the Judiciary Committee, not that rare when the Supreme Court wanted something, right? But this is the mindset. Like, we don't have to explain ourselves to you. We don't have to testify. You can't regulate us. And so this is, he returned to this theme in his year-end report in 2024, where he says, judicial independence, like we have to protect judicial independence, maybe forgetting why we have judicial independence. And so this is sort of the first part of the thesis, that part of how we got to where we are today, that the court we have is a court that, for various reasons, has become unaccountable. All right. Well, so what was different? If this court is different, what made prior courts more accountable? Because many of you guys are in law school right now. Law school is defined by reading Supreme Court cases you disagree with, especially con law, I think. The day I find a con law student who agrees with every case they read is the day I find a con law student who didn't read all semester. Could exist. All right, so I don't want to do like the whole history of the Supreme Court, but I do want to stress a bunch of levers that Congress used to pull as ways of sort of nudging the court, as ways of keeping the court at least loosely in line with what Congress wanted. The point was not that Congress could control specific outcomes, but rather that Congress was just sort of loosely keeping the court from falling all the way off the rails. So what are some examples? The number of justices. Here's a popular one, right? Obviously, it's a lightning rod today, but from 1789 until 1869, Congress changes the size of the court 7 times. And at least 5 of those are political, right? At least 5 of those were doing it for maybe not partisan political gain, but to address some kind of policy debate, right? To reflect some kind of policy preference. Where the court sits, you probably haven't thought about this one very much. You guys like, the court sits in Washington. So first of all, even that is statutory, right? The fact that the Supreme Court sits at the seat of government is actually a statute that Congress passed. But the fact that the court has its own building actually was not true until 1935. Indeed, it was really important to Congress all the way throughout the 19th century that the court was physically located in the Capitol, right? How many of you guys have ever lived in your parents' basements? How many of you are still living in your parents' basements? You faculty? Right? This was not an accident. This was a way by which Congress leveraged the court. Like, hey, we'll turn your lights on and off. Indeed, part of the movement for the court to get its own building, which was championed by William Howard Taft, was to make the court more independent, right? When the court sits, another one you probably have not thought about that much. The fact that the court's term starts on the first Monday in October, entirely up to Congress. It's only been true since 1917. If you remember your Marbury versus Madison, Congress made the court's entire 1802 term disappear because they didn't really want the court to sort of come back too quickly when they were messing with it. Right? It was a not so subtle message to the court. Hey, we can make your term disappear. Guess what else we can make disappear? Congress, again, uses this at least as a bit of a lever. The court's budget, right? This one's my favorite. So do you guys have any wild guess? What do you think the Supreme Court's annual budget is? $1 billion. All right, so no one wants to guess. $151 million, okay? $3 million of that is the justices' salaries. If you know your Article 3, Congress can't diminish the justices' salaries. That means 98% of the court's budget is not required by the Constitution. In the old days, that's what Congress would call leverage. Right? Here's a good example of how. This is a real statute. I did not make this up. Right? It's an 1882 statute. If you can't read it, I will paraphrase. And those of you who can read it, you can tell everyone else if I'm paraphrasing it accurately. "Dear Supreme Court Justice Ward Hunt, we want you to retire. So tell you what, if you retire in the next 30 days, we'll give you a pension. Love, Congress." I do not think that is an unfair paraphrase of what this statute says. Guess what Ward Hunt did? Took the money, right? He retired. This is not the only time Congress does this. Congress does this again in the early 1900s for Justice Moody, right? "We want you off the court. Here's money." Everyone got really upset last year when John Oliver did an episode of Last Week Tonight where he offered Clarence Thomas $1 million to resign from the court. And I'm like, precedent, right? This was not like an earth-shattering, constitution-altering statute, but it was just another little example of all the little ways in which Congress messed with the court. But the most important two were messing with the justices' travel. So you guys might have talked about circuit riding in the run-up to Marbury. We have gotten out of the business in law school of teaching just how much the justices hated riding circuit in the 19th century. But holy moly, they hated riding circuit. Why? It took a lot of time. It was inconvenient. Let's just say that the lodging was not exactly luxurious. Right? Before railroads, you were traveling across the country in a stagecoach. Justice Samuel Chase almost dies when his stagecoach crashes through a frozen river in 1800. Right? John Marshall actually does die from injuries suffered in a stagecoach accident. Right, when he's on his way back from riding circuit. This was not an insignificant thing, and it was also not an accident. Congress kept doing circuit riding as a way of humbling the court. There's a famous quote during an 1828 congressional debate where a then unknown member of the House talks about how otherwise, if the justices just spent all year in Washington, they'd become insular, and they'd be isolated from the people, and they would lose sight of what their job is. The problem is that the guy who said it was James Buchanan, and we kind of are down on James Buchanan, but it's actually a fascinating quote. Like, that's what Congress thought it was doing. It was humbling the court. It was keeping the court in line. Paul Freund, the Harvard law professor, would later describe this as the justices were not supposed to be sort of controlled by the weather of the day, but they were supposed to be sensitive to the climate of the age. And that's what Congress was doing. Like, hey, court, don't get too out over your skis. And the biggest way Congress did this, because we're lawyers, we can appreciate the nerdistry of this, was through Congress's control of the court's docket. Right? Congress, until 1891, controlled every single feature of the Supreme Court's docket. If the Supreme Court heard a case between 1790 and 1891, it's because Congress told them to. Right? Appeals were mandatory. The party had to take the appeal, but once they did, the Supreme Court had no discretion to deny review. That has totally flipped over today, right? Today, almost all of the Supreme Court's docket is discretionary through certiorari. This was not the original idea. This was not inevitable. This was a policy choice that Congress made slowly, progressively into the 20th century, largely at the request, again, of William Howard Taft, the guy who is the most neglected person in American legal history, which is really impressive because he was really hard to neglect. He was a big guy, right? We big guys, we have to look out for each other, right? But Taft's vision for the Supreme Court was more control over its docket and its own building as a way of making the court more independent, more powerful, more sort of immune to all these pressures. Okay. So we have like these examples where we see how this relationship really works in real time. The denouement in Marbury, right? In Marbury, John Marshall has to do the bizarre thing where he makes up this stuff about the Judiciary Act of 1789 because the case that he really wanted to push back against the Jeffersonians in, he couldn't. Would have destroyed the court, right? So he lives to play another day. 1869, right? The court is about to potentially strike down military reconstruction. Congress makes the court's jurisdiction go away. The court unanimously upholds the statute. Salmon Chase, yes, his first name was Salmon. I don't know what his parents were thinking, right? Salmon Chase writes an opinion where he says, you know, you didn't really do what you think you did, Congress. So again, living to fight for another day. The switch in time in 1937, Congress, right, is not really going to pass Roosevelt's court packing plan. It was actually on its way to being killed by congressional Democrats, but the court didn't know that, and so the court blinks when FDR is basically holding a gun to the court's head, right? The court is responding to pressure. The court is shaped by the need to not inflame, to not provoke, to not piss off, right, Congress and the president. But perhaps the best example is the resignation of Justice Abe Fortas. So Abe Fortas resigned from the Supreme Court on May 14th, 1969. That date is relevant because it's the last day on which a majority of the Supreme Court had been appointed by Democratic presidents, like since. As I like to say, it was before the Mets won the World Series. Once they won their first World Series, it all went downhill from there. Or before man walked on the moon, if you prefer your 1969 data points. Why did Fortas resign? So Fortas was caught up in what by today's standards looks like a pretty weak ethical scandal. He had taken a $20,000 payment that he had returned to provide services to the sketchy financier, Lewis Wolfson. By the way, I gave a version of this talk a couple months ago where one of Wolfson's kids was in the audience. Any Wolfsons here tonight? Okay, you never know. Right, why did Fortas resign? He resigns because Earl Warren goes to him and says, Abe, you have to resign for good of the court. If you don't resign, Congress is going to come after us. And so Fortas resigns. Warren had already announced he was resigning. And right away, Nixon gets two very important seats to fill. And the court is shifted because the court was worried about Congress. That was how things used to go, right? The court was looking over its shoulder. That didn't always necessarily produce results that we might have liked. It produced results that were institutionally healthy and that kept the institutions talking to each other. All right, so what changed? The first thing that changes is, I will just say, Taft's fault, right? So Taft, probably most famous, right, for the, I will just say in his defense, apparently apocryphal story that he got stuck in a bathtub. There's no actual evidence this ever happened. No bathtub has been produced. Right? Taft, after he's president, actually devotes the rest of his career to Supreme Court reform. First when he's back at Yale as a law professor, and then when he's appointed Chief Justice in 1921 to succeed Justice Edward Douglas White, a Louisianan, as I understand, right? There's my one professional Louisiana reference for the night. Also a Confederate War veteran, but details. Taft's vision of the Supreme Court was one in which the court had more control. And so in 1925, the most important statute even most lawyers have never heard of is a statute called the Judiciary Act of 1925. It was known then colloquially as the Judge's Bill. Why is it known as the Judge's Bill? Because the judges wrote it. Right? Taft and a couple of his colleagues wrote most of the statute. And the statute was designed to give the Supreme Court more independence by turning most of the court's docket into discretionary appeals, certiorari, right? The statute gave the court more power by giving the court money to find and build a court building, which happens after Taft dies, but he starts the process. And so we start to see in the 1920s the court coming out of its shadow, the court picking the cases it wants and not taking the cases it doesn't want. It is not a coincidence that in your common law classes, the majority of cases that you read are after 1925. Because as one of my friends, Ed Hartman, who teaches at Seton Hall, says, that's the day on which the modern Supreme Court is born. One example of how this works, think about incorporation. When the Supreme Court takes a provision in the Bill of Rights and applies it to the states. At a time when the court has mandatory jurisdiction, saying, for example, the right to unanimous convictions, right, applies to states like Louisiana, would immediately provoke hundreds of appeals that the Supreme Court would have to decide from fellow Louisianans raising the same claim. With a cert docket, the Supreme Court can duck all of the second-generation cases. Right? With discretion, the court in 1956 can duck the question of whether anti-miscegenation statutes, laws that ban interracial marriage, are unconstitutional after Brown. They ducked that for 11 years because they could duck. Right? And in ducking comes power. So that's the first thing that changes is the court is given control and takes even more control over its docket. The second thing that changes is Congress starts gradually abandoning other levers. It gives up control over the docket. In 1937, actually, the part of the court packing plan no one ever talks about is the one statute Congress passed, which created a permanent retirement system for the justices. Right? No more ward hunts. Now every justice is guaranteed what ward hunt got. And Congress can't change that without causing constitutional problems. Right? 1964 is the last time Congress uses its power over the justices' salaries as a way of leveraging the court. Now you might be saying, wait a second, Article 3 says Congress can't diminish the justices' salaries. But the 1964 statute is hilarious. To catch up with post-war deflation, Congress in 1964 finally gives every federal employee a pay raise. Right? There's a bit of a budget surplus. Like, all right, we're finally going to catch salaries up. The 9 federal employees who got the least amount of pay raise were the justices. Why? Because Congress was mad at them because of Reynolds versus Sims, the redistricting case. Right? Not violating Article 3. They didn't diminish their salaries. We just gave them less more. Right? Congress has stopped doing that. One of my favorite examples, I actually, in another set of these slides, I have the video of it. Justice Kennedy, in spring of 2001, is testifying before the House committee that does the Supreme Court's budget. Usually it's like this, pure vanity project where 2 justices go up to the Hill and they, answer totally softball questions about the court. That year, there weren't softball questions. That year, all of the questions were, what the hell was Bush versus Gore? And Justice Kennedy actually is sitting there defending Bush versus Gore to a congressional committee. I think that was actually super interesting and actually really useful, and we don't do that anymore. Right? Congress has stopped pulling these levers. The hollowing out of the court center. Those of you who are younger than I am may not necessarily know the name Harriet Miers. Right? Harriet Miers was President Bush's second choice to replace Justice O'Connor. First choice was John Roberts, then Roberts slides over to Rehnquist when Rehnquist dies. Right? Harriet Miers was supposed to be the next successor to O'Connor. Harriet Miers gets killed from the right. Right, as not being reliably enough of a conservative, which is the first time we had seen that. The first time that a president's nominee was killed by the president's own party for not being sufficiently ideologically sympathetic to the president. Instead, we got Samuel Alito. That was a pretty big difference. Right? But that set a precedent for the nominations and confirmations to follow. And then my favorite, this is again, I started with the picture, which is really not especially important. This one too, in 2010, the court finally, formally, officially closed its front doors. The big 17-foot, 13-ton gold doors at the front of the court. In 2010, those were permanently closed, right, except on argument days. Why? Ostensibly for security. But Justice Breyer, architecture critic qua Supreme Court justice, wrote a remarkable statement that's basically my favorite dissenting opinion of his on how, even if it was necessary for security, the court is literally turning its back on the public, right? That all of the concerns that led Congress to not let the court have its own building have now been sort of manifested and multiplied. All right, so that's what changed. Supreme Court we have is a court that does not think it is accountable, and Congress, for various reasons, has stopped pulling the levers. The court we had was by no means perfect, did lots of bad stuff, but it at least was part of this healthier dynamic. So how do we get it back? Why do we need the old Supreme Court versus the new one? After all, the old Supreme Court is the court that gave us Plessy. Right? It's the court that gave us Lochner. It's the court that gave us other decisions that at least many of us have come to disfavor. Why would we be better off? All right, well, let's start with the obvious. The Supreme Court cannot enforce its own mandates. It's common to say the court has no police force. It's actually not true. It has a police force. But the Supreme Court police's job is just to protect the justices in the building. Right? No authority to go beyond that. Instead, going all the way back to 1790, the third rule the Supreme Court ever adopted provides that the Supreme Court's formal rulings, its mandates, are issued in the name of the president. That's a remarkable thing that historically has not been that controversial, right? That presidents thought it was their obligation to enforce Supreme Court decisions, even those with which they disagreed. Right? So this is Little Rock Central High School in 1957. Eisenhower said, by the way, there is a version, I got to change this picture. There's a version of this picture where you can see in the background Jerry Jones, the owner of the Dallas Cowboys. Let me just say he's not one of the troops. And I'll leave it to you to figure out what role he was playing in the picture. Anyway, this is in 1957 when President Eisenhower, who was not the most zealous advocate of civil rights, sends the army in to desegregate Central High School. Right? Why? Because Eisenhower thought it was his obligation to enforce Brown, especially against states that were overtly defying it. Right? Eisenhower was enforcing the mandate. What prevents parties from defying the court? Popular support and then the army. Right? Historically, that's been the mandate. What prevents presidents from defying the court? So let's talk about the Watergate tapes case for a second. Right? On July 24th, 1974, the Supreme Court rules 8-0 that President Nixon has to turn over the remaining Watergate tapes. Why did he comply? Right? Nixon actually spends a couple of hours talking to his advisors about whether they could defy the ruling. He asks one of them, is there any air in it? Meaning, like, is there any room for us to, like, defy it? Why did he comply? Because Nixon was persuaded that if he did not turn over the tapes at that point, it wasn't that he would be impeached. He was already going to be impeached. Right? The Judiciary Committee in the House had already voted out articles of impeachment. He was convinced that if he defied the Supreme Court, he'd be convicted in the Senate. Right? He had bet his entire political future on having enough Republican support in the Senate that he'd be acquitted in an impeachment trial. That, of course, nothing has happened since then to give us any reason to think that that was a viable thought. That was sarcasm. Okay. So Nixon turns over the tapes because he's persuaded that if he doesn't, not only is his impeachment guaranteed, but his removal is guaranteed. Well, small problem, right? He turned over the tapes, the smoking gun tape comes out, and his removal was guaranteed anyway, and so he resigns. But even Nixon, right? Even Nixon did not seriously contemplate refusing to turn over the tapes and defying the subpoena. Why? Because the Supreme Court in 1974 was immensely popular. Not because every decision it handed down was supported. This is the same Supreme Court that had just handed down Furman versus Georgia, which had imposed a nationwide moratorium on capital punishment, which was much more divisive in the moment it was handed down than Roe versus Wade was. Right? This is the court that in San Antonio versus Rodriguez in 1973 had said, no, we're not going to hold that the Constitution requires states to provide minimal educational equality when it comes to resources. Right? The court wasn't like everyone's favorite, but the court was viewed as institutionally responsible. And presidents didn't have the ability to defy it. All right, fast forward to today. This is a Truth Social post by the current president of the United States about one of the judges in DC who ruled against him in the alien enemies litigation. I'm not going to read the whole post because it would take too long and my head might explode. Right? But we have a very different situation right now, not just because of who the president is, but because of who Congress is. Right? Nixon knew he had to comply with the Supreme Court's ruling because of the consequences he would face in Congress. Eisenhower sends troops into Arkansas because he's worried about the political backlash. And the question is, right, what is actually going to stop the current president from defying an adverse Supreme Court ruling? This is why it's so important that the Supreme Court be popular, right? Because part of what makes this moment, from my perspective, so precarious for our Supreme Court is that it probably doesn't have the degree of support that the court had in 1957 or 1974, and that that's actually something that will make it harder for the court to stand up to the president, whether directly or indirectly. All right, so this is the bottom line, right? Why do we need a more powerful, more popular, more accountable Supreme Court? Why not just weaken it? Why not add 6 seats to it and then, you know, it'll have less power? Why not take away its jurisdiction? Why not keep it out of our disputes? And so I guess there are sort of 2 pieces to this. The first is, I think our experience over the last 9 months has provided lots of evidence for how in our constitutional system, courts are actually a pretty important backstop. That perhaps especially when Congress is not in a position to assert itself institutionally, we need courts, including the Supreme Court, to at least have the nominal authority to stand up to the president. But the second part of this is, And we need a court that is popular because if and when that moment comes, the court's ability to stand up, whether it's to the president or to Congress or to state legislatures, will depend upon the court being popular, not just among its friends. Right? And so we need a court so that if we ever get to a moment in which a president's thinking about defying it, the cross-spectrum political consequences are so cataclysmic that he's impelled to comply. And that moment may be coming sooner, right, rather than later, maybe even sooner by the day. Right? So the court we need is not a weaker court. It's not necessarily a court with more democratic justices. Right? It's a court that's more accountable. How do we get there? All right? So part of what I hope you have been at least implicitly intrigued by tonight is that when we talk about the Supreme Court in institutional terms, as opposed to as the sum of its merit decisions, it's a very different conversation. Right? We're not talking about, is originalism a viable theory of constitutional interpretation? Right? We're not talking about like textualism. We're not talking about what does the Eighth Amendment mean. We're talking about what is the court's relationship with the other institutions of government. When we talk about the court as an institution, I think there's much more room to persuade people who may not see things the same way as you do or I do or we all do, that something's wrong, right? That the court actually has gotten a bit aloof from the other branches of government. This also, I think, lends itself to pushing for reforms that will make the court more accountable. Not necessarily more justices. There's no guarantee that with 6 more justices we'll have a more accountable court. They could be 6, Democratic jerks, right? Docket reform. I know everyone gets really excited about docket reform. It is the top of everyone's tongue. Like, yes, less certiorari. No one's excited about docket reform. An inspector general, right? Instead of spending so much time fighting over whether Justices Thomas and Alito have violated various ethical rules, how about having an internal ombudsperson whose job is to actually monitor the justices' behavior, right? These are not about ideological retaliation. These are about enhancing the public perception of the court as an institution. And I think the last point, and perhaps the most important one, we have at least some evidence that institutional reform pressure has already moved the court on ethics. The court adopted this code of conduct. Now, to call the code of conduct a half measure is to do grave injustice to half measures everywhere, right? But the fact that the court did something at all was actually remarkable, and they did it fast, within 7 months of ProPublica's first reporting. The court had done, that was a response to public pressure. Some of the changes in the court's behavior on emergency applications have been a response to public pressure. When the conversations in institutional terms, the court actually does begrudgingly listen. They won't say that they listen, but they hear us. We need more of that. So that's why I write my crazy little newsletter. It's why I wrote the book, and it's why it's a real honor to be with you tonight. And I'd love to take a couple of questions if we have time. So thank you very much. Questions? I think we have like 10, 15 minutes, maybe? Unless, you have no question, we're good. Sir, all the way in the back.
I've been studying this lecture series on how republics die.
Yes.
And I don't know if
Very, very uplifting.
I know. And I'm wondering if you think, in sort of a similar way that we saw, the rise of Julius Caesar and the fall of Rome, and how the rule of law crumbled, and the consequences of that, if we're in unprecedented times now, and if you see our republic, healing.
So I think 2 things are true. I think there's no question that we are in unprecedented times. But I want to be clear on why. I think what makes these times most unprecedented is actually not the president and it's not the Supreme Court, it's Congress. Right? That we are not designed to function in a very, to function over more than a very short period of time with a legislature that doesn't think its job is to legislate. And there are various ways in which this has manifested itself, right? This is Congress ceding appropriations power to the president. The Senate confirming even people who, at least from my perspective, are grossly unqualified for their positions. Right? There are so many ways in which a lot of what President Trump is doing is behavior that would not have been stopped by courts in prior administrations. It would have been stopped by politics. It would have been stopped by even members of your same party, or it might not even have ever been undertaken because of the political pushback. And so to me, the crisis we face is a crisis of Congress. James Madison wrote in Federalist 51 that the way the separation of powers is going to work is not by having wonderful people, right? It's by setting the institutions against each other. He says ambition must be made to counteract ambition. We have a remarkably ambitious executive right now. We have a very ambitious Supreme Court. We have a feckless Congress. And so I don't know that this is akin to the Roman example. I actually am very persuaded it's not akin to the late Weimar example because there are profound structural differences. But what we have at the moment is a universe in which what's inevitably going to happen is increased confrontations between the executive and the judiciary. And I think what we've seen to this point in 2025 is at least most of the judiciary doing, from my perspective, a pretty remarkable job of serving as at least something of a check. Even the Supreme Court, as it has greenlit so many of these Trump policies, that's really a very small minority of the total number of cases. My concern is it's a rearguard action, and that we really do, I think, need a Congress that at some point is going to reassert itself. And so that's why, from my perspective, it's the midterms that are so important. And the possibility of returning even one branch of government doesn't have to be a Democratic majority, but just, even if there's a slim Republican majority where the critical votes are folks who have some institutionalist tendencies, I think that's what's needed. But I also think that's possible. I mean, the gap between where we are today and what that would look like is really not that many points nationally.
I like the more optimistic view.
Listen, I'm a Mets fan, okay? My life is unjustifiably optimistic views. So, I saw a hand over here. Maybe it is over there, sir.
So President Jackson allegedly said that the Chief Justice has made his ruling, let him enforce it.
Also apocryphal.
Okay, not true.
He didn't quite.
Oh my God, are we headed there?
So are we headed there is, I'll get to that in a second. So the Jackson story really quick because I love this story. The first time that quote actually appears is in something Horace Greeley writes in the middle of the Civil War. Now, that may not be persuasive to you. I think the better persuasive point is that the federal government was not a party to the case he was talking about. Andrew Jackson supposedly said this in response to the Supreme Court decision in a case called Worcester versus Georgia, which is about the removal of Cherokees from northwest Georgia. The federal government had nothing to do with that case. And so even if Andrew Jackson didn't want to enforce it, there's nothing that he was supposed to do. Now, what would happen if Trump did that, right? So I think this is part of what's going on with the Supreme Court right now. I think there are at least a couple of justices in the majority in at least some of these cases who, don't want to unnecessarily provoke confrontations with this particular executive at this particular moment. I will say, I think it is worth stressing that the president's support in Congress, I think oftentimes appears stronger than in my view it really is. It would not take that many Republican members of the House to, if not defect, at least vote with the Democrats in response to a President Trump not complying with a Supreme Court decision to impeach him or even to just sort of thwart his agenda. It would take 4 senators. Now, on a day like today, that seems like a heavy lift. On the day after this Supreme Court has been defied by President Trump, I'm not sure how heavy that lift is. And I think there's a reason why we haven't seen that yet. One of the most, guys, remarkable exchanges to me during the birthright citizenship oral arguments back in May was Justice Barrett, and I think it was really striking that it was Justice Barrett, really goes after the Solicitor General on whether the administration would comply with a Supreme Court ruling that the birthright citizenship order was unconstitutional. And she starts at this by asking, will you follow circuit precedent? And Sauer equivocates, he hems and haws, he gives the really actually standard DOJ answer about how not all circuit precedents equal. And then when they get to, but will you follow our precedent? Where historically, by the way, DOJ's position has been tricky. Sauer says yes. Like he just, concedes it without even a fight. That I think was a strategic concession by him in the moment where he would lose the case if he didn't say that. But I also think it was meaningful from the Supreme Court's perspective, and it actually shows up in the majority opinion. So, I worry about this, but I don't think we're quite as close to that particular cliff as maybe some of the justices do. Yeah, sir, in the back.
I'm a huge fan. Let me start off.
Oh, thanks. That's just because you don't know me. I'd be honored to sign your book. I'm happier to answer that question. I was not, so I think you guys probably have a bit of a flavor for how I want Louisiana versus Calais to come out. I was not confident after the oral argument. Well, I wasn't confident before the argument. I was even less confident after. To me, the question is there a way for the court to narrow the ability of states to draw majority-minority districts without scrapping it altogether? It's wild that that's the conversation that we're having right now, but I'm not convinced that that's not where the court ends up, that there isn't like a split among the Republican appointees where 3 or 4 of them want to scrap majority-minority districts altogether, and then like Roberts and Barrett have this narrower reason why Louisiana gets to redraw its map, right? I have deep problems with the entire move behind that jurisprudence. There is something radically different about drawing districts that are specifically designed to remedy prior instances of de jure racial discrimination, which in the affirmative action cases was always sufficient, versus the move that causes trouble in the affirmative action cases, which is away from remedies for past discrimination and toward diversity. That's not this, but I think it's not going to go well. I think the question is how bad. And I'm not convinced it's the worst case scenario yet, but I'm also more worried about that now than I was before the argument. But I'll still sign your book if I haven't depressed you too much. Sir?
Do you think, this is my personal view, do you think if the nation moved from this political extremism and, division that's in the country right now clearly, do you think if the country was to more so get back to civility, that might give Congress some power and the Supreme Court some legitimacy?
Yes. So the short answer is yes. The longer answer is which is the chicken and which is the egg. Right? And what I mean by that is, is it changing our personal politics first that causes the institutional reform, or is it institutional reform that might get us to, see eye to eye on some issues with people on whom we don't usually see eye to eye with things, right? When I go out and talk to, let me just say, audiences that might be less sympathetic to my views than many of you, I think, are, right? They're often surprised by some of the history, right? And surprised by some of the court's behavior. I mean, it is very hard to come up with a satisfying defense of the Supreme Court handing down orders it won't explain and then telling lower courts that they have to follow them in other cases. Like, there's no real defense to that. And so, I don't know if that's a broader lesson that can be extrapolated for how to find common ground. Like, hey, maybe Congress should have the appropriations power, no matter who the president is. Or whether it starts at the ground level with, building back up networks of respect and common purpose. But boy, do I think we need both of those things. And I'm happy to start wherever I can start. So a lot of my work, right, is about sort of more of these kinds of institutional reform conversations. And, for as much as my friends in my social media replies might suggest that this is of convenience because of who the president is, right, I was just as critical of the Obama administration in context in which I thought it was defying conventional norms of accountability, including your not related cousin, Edward Snowden, right? It has to start somewhere, and I don't care which one it is, but let's pick them both and meet in the middle. That's my view. Yes, yeah.
When you mentioned an inspector general that oversaw that can't oversee the Supreme Court,
Yeah.
how do you believe that person should be selected or elected to avoid being tainted by party polarization?
Yeah. So I think there are constitutional constraints where I think the inspector general would have to be appointed by the court, but it would be the full court. It wouldn't just be Chief Justice Roberts. And actually, I think that would lend itself to, not necessarily the person I would pick, but someone who I think would be generally responsible. Right? There are ways. So every time I bring this up, right? There would be you can't give anyone control over the Supreme Court. The point of the inspector general is not to give someone control over the court, right? The point is to create public accountability. So imagine a world, right, in which the Inspector General every year audited the justices' personal financial disclosure forms and said, oh, hey, Justice Sotomayor, you forgot to disclose this book income. Or, hey, Justice Alito, you should have recused in that case. Imagine if that first step happened internally and the justices actually had a chance to correct stuff internally, right? And then if they didn't correct it, it would be publicized. Right? That's the kind of pressure we want to be creating, right? Pressure to behave in ways that are not going to look bad if they're made public. But also pressure that when it does become public, doesn't get pigeonholed as a left-wing media organization, right? Which ProPublica, I don't know, really is, right? So there's lots of reasons why each of my little individual proposals are not perfect. But there's so much room between where we are and what I think perfect is that it seems like let's try some stuff, and that's one of them.
Doesn't that allow them to make the error in the first place?
So maybe, but there's a good history, at least in some agencies, right, of the internal correction process actually creating an internal culture of accountability, right, where if you are not faced with the choice of deny and like pick a fight versus going public, if you can correct quietly and privately, people do, right? Versus I caught you, I'm publicizing this, right? Like it creates more of a culture of internal accountability, which I think is what's missing at least part of what's missing right now.
But they could also think if I can get past you, I can get past them.
That's right, but right now they don't have to get past anybody. I think we have seen over the course of the last year and a half, right, why the court of public opinion is not the most effective tribunal in which to measure the justice's behavior. Yes, ma'am.
Okay, I was going to ask about that. I guess this question is more a point of clarification, but I think I heard you use the word popular in reference to courts in the past, and they were more popular. And I'm going to zero in on that word, popular.
Yep.
Popular meaning like the court or trust the court whether we like them or not.
Much more the latter than the former, right? Popular as in respected the court as an institution. And so, there's not, I will say, just to be clear, there are limits on the research here because there wasn't significant public polling data on the Supreme Court until the 1960s. But even if you go off of just relatively anecdotal studies in the political science literature and to a lesser degree in the legal literature, because we lawyers are really terrible social scientists, right? There is a very deep history of talking about the Supreme Court's public respect, right, and credibility as distinct from support for individual hot-button decisions. And so part of what happened in the build-up to the 1937 episode is that was the last example of a long-sustained period of eroding public faith in the court, of decreased public faith, of less popularity, which is reflected very much in the election of 1936. When FDR, right at the end of his first term, where his biggest obstacle has been the Supreme Court, largely runs against the court. And he wins a massive mandate. Democrats are returned in supermajorities to control both chambers of Congress. And so FDR sets his sight on the court and comes after it with the court packing plan. Right? At that moment, the court was deeply unpopular, which is what made all of that possible. But it was still popular enough that destroying the court, as everyone thought the court packing plan would if it went into effect, right, became a real fight amongst Democrats in Congress. And that was enough of a concern that two of the justices moved their own votes, right, to sort of diffuse all of that. That's the kind of sort of multifaceted discourse that I think helped the court manage those prior crisis points in ways that I think today's court is either unwilling or unable to.
Okay, one more.
Yes, ma'am.
First of all, thank you for being here and talking with us. And secondly, where do you think the Supreme Court gets its courage or cowardice?
Gets its courage or cowardice? Wow, that's a great question. So I think the best answer to that question is that in that respect, the court is a they, not an it. And it's 9 people. And the question is, Justice Brennan used to say the most important rule on the Supreme Court is the rule of 5, right? How do you get to 5 for courage or cowardice? So I'll just say, when I look at sort of what I see as the big rule of law fights to come, And I'm trying to figure out who are the 5 justices who are most likely to stand up if this administration keeps pushing the envelope. I think the first 3 are obvious, and I think the next 2 are Amy Coney Barrett and John Roberts. And you know, Brett Kavanaugh might vote against this administration, but he'll never be the 5th vote against this administration.
What's stopping that?
What is stopping that? I think from the perspective of Chief Justice Roberts and Justice Barrett, that case has not yet reached them. I would have thought it had. I have a couple of examples. I think that the Illinois National Guard case the court is sitting on right now is a very important litmus test for the court. I wrote in my newsletter on Monday that I think this really is a make or break moment for the court to a much greater extent than any of the first 28 applications. But I think that that Roberts and Barrett to this point have told themselves a bit of a story that they haven't actually said any of this is legal yet. And I think that's naive. I think that's missing the extent to which what's happening in the interim is quite disruptive and destructive. But we're getting there soon. And you know, I'm hoping more than I'm confident about what's going to happen.
Well, that's where courage comes.
So
Yes, ma'am.
I have a question as well.
Please.
And so you've been telling us a story of power. And 2 things. One is you've talked about some of these reforms happening within the Article 3, right?
Yep.
But you've isolated the problem saying this is Congress
Yes.
being feckless.
Yes.
So what reforms would you suggest around reducing the fecklessness, right? And so if the campaign, finance stuff is what's really kind of let the cow out of the farm, then what are we going to do? The second part of this, though, is states are a center of power, and even though they have no constitutional oversight, they are still sites of organizing, of strategy, and ultimately of movements.
Yep.
Right? So could you talk about those 2 sources of power as and the roles that they might play in
Yeah.
constitutional legitimacy?
So I'll just say, I think one of the last great moment of real institutional reform in the United States was the late 1970s, right? And it was largely a response to Watergate, although in some respects Watergate was just the last in a line of things. And the late 1970s are characterized by 2 things. A Congress that has plenty of Democrats and Republicans who are committed to reining in the executive. And more importantly than that, a president who is not just a passive, non-opponent, but who's affirmatively invested in it, right? I mean, to Jimmy Carter's great credit, he was actually deeply supportive of most of the statutes Congress passes in the late 1970s that reined in the executive, the Ethics in Government Act, IEPA, the International Emergency Economic Powers Act, the Foreign Intelligence Surveillance Act, which reins in surveillance powers, right? There are so many of these statutes, and Jimmy Carter signs all of them. And he sends his lawyers up to Capitol Hill to testify in support of most of them. And so, I actually think part of what we're missing here is the viability at the national and potentially state level of someone who says, listen, I'm sympathetic to many of your views on social policy. Many of you will disagree with me on social policy, but can't we all agree that our government needs to be more accountable, right? Imagine a world in which we actually had liability for federal law enforcement officers who break into your house without a warrant, hypothetically. Right? To me, part of this actually, yes, it can start at the bottom, although there are lots of structural reasons why that's hard, gerrymandering perhaps foremost among them, right, which makes the primary more important than general election. But I guess I haven't given up yet on the possibility that the Democratic Party might actually have a candidate in 2028 who says, I want to rein in the presidency. That was not Joe Biden. It was not, bless his heart, Barack Obama, right? It wasn't Bill Clinton, right? And so maybe the real lesson here is that for as much as maybe Democrats are aligned around social policy, there's an opportunity to become the party of institutional reform. I think that would be a much more, I am not a political expert. I am an amateur. I just live in Washington. I stayed at a Holiday Inn Express last night. I blew that line. I started to say Marriott. I don't know. But I actually think it comes from the top, not the bottom. And we've gone too long in American history without a president who thought that the separation of powers was part of against the executive was actually part of their job.
Thank you.
Thank you all very much.